I see it's 9 o'clock. Why don't we call our meeting to order? Let me first start with attendance here. I am present. Commissioner Reddycliffe, I know we have you online. Are you able to hear us?
I am, and I'm present.
Commissioner Parcells.
Present.
Commissioner Caruso.
Present.
Commissioner McKeever-Sala.
Present.
Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to the executive session or at the next meeting thereafter. An executive meeting will be held today, April 16, 2026, immediately following this session to review matters that are by statute confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review and consideration of an application for 90-day extension of an investigation filed by the investigative division, and administrative matters. Our first item on the agenda is the minutes of both the January 14, 2026 public meeting and the March 26, 2026 public telephone conference meeting minutes. They have been distributed, and why don't we take them together if I can? Are there any corrections or comments on those meeting minutes? Hearing none, can I have a motion to approve those minutes?
So moved.
And a second?
Second.
All in favor, say aye. Aye.
Aye, and I will vote
Aye.
as to the meeting that I attended, not to the other meeting.
Understood. And any objections? Hearing none, those minutes are approved. Why don't we move to the civil penalty orders? There is a consent and a number of defaults. Commissioner McKeever-Sala.
Sure. Good morning. So there is one civil penalty case with a proposed consent agreement for our consideration this morning. This case involves respondent Glenn Stoltzfus, and apologies if I didn't say that correctly. Mr. Stoltzfus is a member of the Animal Health and Diagnostic Commission who failed to timely file a statement of financial interest for the calendar year of 2023. The parties have submitted a consent agreement proposing that the commission find that the respondent failed to timely file a statement of financial interest for the year stated and impose the civil penalty that I will detail in my motion. The respondent has now filed his delinquent statements of financial interest for the calendar year 2023. Based upon my review of the facts, I am of the opinion that this consent agreement is a proper disposition for the case. It is my opinion that the commission should impose the civil penalty agreed to by the parties per the consent agreement. So I would like to make the following motion based upon my analysis and comments.
Please do.
I move that the commission approve the consent agreement submitted by the parties, imposing a $150 civil penalty against respondent Glenn Stoltzfus for failing to timely file a statement of financial interest for calendar year 2023. I further move that to the extent that the respondent has not already done so, he be ordered to pay the recommended civil penalty amount agreed to by the parties per the consent agreement within 30 days of our order.
We have a motion. Do we have a second? All right, the motion and second. Any comments or questions? Hearing none, all in favor say aye.
Aye.
Any
Aye.
opposed? Motion carries. Next.
We have 13 civil penalty default cases that are now before this commission for a decision. The respondents involved in these cases will be identified individually in the motion I will make at the end regarding these cases. Each of these respondents failed to file statements of financial interest for the calendar years that I will detail in my motion. The respondents did not take action or otherwise respond to the civil penalty proceedings. Following review, it is my opinion that as to each respondent, the commission should levy a maximum civil penalty for each delinquent statement of financial interests. It is my opinion that the commission also should order that these respondents file their delinquent statements of financial interest. There is nothing of record that would constitute an offense or excuse for their noncompliance with the requirements of the Ethics Act. So based upon my analysis and comments, I would like to make the following motion.
Please do.
I move that this commission levy maximum civil penalties against the respondents in the following civil penalty default cases as follows. I move that this commission levy a maximum civil penalty in the total amount of $750 against respondent Sean McManus for failing to file a statement of financial interest for calendar years 2019, 2020, and 2021. I move that the commission levy a maximum civil penalty in the total amount of $250 against respondent Nate Rivera for failing to file a statement of financial interests for calendar year 2022. For the cases involving respondents William Ament and Hector Santiago, I move that this commission levy a maximum civil penalty in the total amount of $500 against each respondent for failing to file a statement of financial interest for calendar years 2022 and 2023. And for the cases involving the following 7 respondents: Diane Bates, Sean De La Rosa, Jack Betzer, Ronald Simmons, Elizabeth Stella, Kaylin Williams, and Gerline Lurar, I move that this commission levy a maximum civil penalty in the total amount of $250 against each respondent for failing to file a statement of financial interest for calendar year 2023. In the cases involving Carl Ryan, I move that this commission levy a maximum civil penalty in the total amount of $500 for failing to file a statement of financial interest for calendar years 2023 and 2024. And I, as I mentioned earlier, move that these respondents shall be ordered to file complete and accurate statements of financial interest for the year stated within 30 days of the issuance of our order.
Do we have a second for that motion?
Second.
Any questions or discussions about the motion? Hearing none, all in favor say aye.
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 Any opposed? Hearing none, motion carries.
Mr. Chair, I would just ask, is there any way that we could target some training towards like the Department of Human Services, which seems to have a number of these individuals? It seems to me that if there's a group of people, for example, these income maintenance caseworkers,
Yeah.
I'm not sure that they're even, they should be aware, and I'm not excusing that they're
Sure.
aware, but we should do more if we can
Sure.
with our limited resources.
Happy to do that. I do want to let you know that we check the status of these. I checked the status of all of these folks yesterday to see if they were still employees. All of those DHS employees are formers. So unfortunately, they leave, and then DHS, we have to be sending out letters to them and chasing them down. So that's what's happening with that. I do want to note that Office of Administration has a mandatory training for all employees under the executive branch on ethics. So they are receiving the training on ethics. Just don't.
Very helpful context, thank you.
Sure.
All right, let's move on to lobbying. Commissioner Parcells. We have a consent and some defaults. If we can take the consent and the 2 defaults first, the 3rd default, I have to recuse
Right.
myself.
Gotcha. Right, there's one administrative penalty case with proposed consent agreement for our consideration. Respondent HSS Investors LLC failed to timely file its quarterly expense report for the 3rd quarter of 2025 in its capacity as a principal. Parties agree that the respondent's transgression of the lobbying disclosure law was negligent. The respondent has now submitted its delinquent expense report to the Department of State. Based on my review of the facts, in particular the considerable mitigation offered by the respondent as set forth in the order, I am of the opinion that the consent agreement sets forth a proper disposition for this case, and I would like to make the following motion. I move that this commission approve the consent agreement submitted by the parties and oppose the following administrative penalty. As to HSS Investors LLC, one administrative penalty in the total amount of $5,900 for its delinquent expense report for the 3rd quarter of 2025. I move that the respondent be directed to pay its administrative penalty to the commission by no later than 30 days after the issuance of the commission's order.
I'll second that.
All right, thank you, Commissioner Redcliffe. Any questions or comments? Hearing none, all in favor say aye.
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 Any opposed? Motion carries.
Okay. We have two default administrative penalty cases for our consideration. Respondents Spin and Garcia Clinical Laboratory, Inc. are registered principals that failed to timely file either a quarterly expense report or a statement of failure to meet the reporting threshold for the third quarter of 2025. Warning notices were issued to the respondents, but the respondents failed to comply with the 30-day cure period provided. Based on the record before us, it is my view that each of the respondents' transgressions of the lobbying disclosure laws were negligent. In accordance with the Commonwealth Court's decision in Penn Film Group, the record was examined for any mitigating factors such as those outlined in section 63.63 of the Commission's regulations. Other than this appearing to be the first time either respondent failed to file a quarterly expense report, there is no evidence of any other noteworthy mitigation present in these cases. In the absence of any other mitigating factors of record, I conclude that maximum civil penalties in accordance with section 13A09C of the lobbying disclosure law are appropriate in each case. So, based on the totality of the circumstances in these cases, including the lack of any significant mitigating factors, I move that this commission levy upon respondents Spin and Garcia Clinical Laboratory, Inc. one maximum administrative penalty each in the amount of $31,100 for their failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the third quarter of 2025. Finally, I move that the respondents be ordered to pay the aforesaid administrative penalties by no later than the 30th day after the mailing date of the Commission's order.
Commissioner Parcells, if I may, before I move for a second on this, I have additional information to present regarding one of the respondents in this case, or in one of these cases. Garcia Clinical Laboratories did file their third quarter quarterly expense report on February 3rd, 2026. We were unaware that they had filed as they had done that after we had filed the petition for administrative penalties, and therefore we believe, the investigative division believes, that the calculated amount for the penalty should be lower than the $31,100.
They were recommended.
So I had spoken with the chief counsel about this, and they had recalculated. I believe the office of chief counsel had recalculated the amount.
We did. We recalculated the amount based upon the February 3rd filing date, and the amount would be $20,600 for Garcia.
And I'd like to also note that we've had some discussions within the investigative division about how to prevent this from happening, where we have prepared materials and then discover, while preparing for the hearing or for the commission meeting, that they had in fact filed. We plan to do a check at the time that the public, prior to the agenda materials, are being circulated.
Can I just ask a question before we proceed? Other than that filing, are there any other factors that we should consider under Penn Film Group that may mitigate it further, other than that the days that were outstanding were less?
Not that I believe. And I believe so either. I have not learned anything else.
Was there any explanation submitted with the filing or
Yeah, that was
any
my
other
question.
information?
No explanation, no
They
contact.
just filed.
Yeah, they just filed.
Are they aware of the, so usually we do reach out ahead of time, right, through certified mail, and I apologize if this is the material, so they should be aware.
They would have gotten that warning letter which lists those penalties.
And I do believe that just my review of
Yeah.
it, that there is a return certified.
It's
And
so odd that you would pay and not
Yeah, right.
respond to that, but you chose to do that.
okay, so
So
in light of that, do you want to revise your motion?
Yeah, I would revise the motion for the administrative penalty for $31,100 to spin and $20,600 for Garcia Clinical Laboratory.
Can I have a second to that motion? Right. Any further discussion or questions on that motion? Hearing none, all in favor, say aye. Aye.
Aye.
Aye.
Any opposed? No. Motion carries. The next matter involves Scholastic Inc. My law firm, Troutman Pepper Locke, has represented Scholastic. I have not personally, but in an abundance of caution, I am going to recuse myself from this matter. So I will step out and someone can call me when you're done.
Okay. All right, there's one default administrative penalty case for our consideration. Wait, Mary. He doesn't have his ear to the door. Respondent Scholastic Inc. is a registered principal that failed to timely file either a quarterly expenditure or a statement of failure to meet the reporting threshold for the third quarter of 2025. A warning notice was issued to the respondent, but the respondent failed to comply with the 30-day cure period provided. Based on the records before us, it is my view that the respondent's transgression of the lobbying disclosure law were negligent. In accordance with the Commonwealth Court's decision in Penn Film Group, the record was examined for any mitigating factors such as those outlined in section 6363 of the Commission's regulations. There is no evidence of any noteworthy mitigation present in this case. In fact, there is an aggravating circumstance of this being the respondent's second delinquent filing occurring in 2025. The absence of any mitigating factors of record, I conclude that the maximum civil penalty in accordance with section 13A09C of the lobbying disclosure law is appropriate. Based on the totality of the circumstances in this case, including a lack of any mitigating factors and the aggravating factor of this being the respondent's second delinquent filing during 2025, I move that the Commission levy upon respondent Scholastic Inc. one maximum administrative penalty in the total amount of $31,100 for their failure to timely file with the Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the third quarter of 2025. Finally, I move the respondent be ordered to pay the aforesaid administrative penalty by no later than the 30th day after the mailing date of the Commission's order.
Thank you, Commissioner Parcells. Do we have a second on that motion?
Before we have a,
Yeah, and I have a question too, even though I
This
made
would
the
be
motion.
their third.
This is their third?
Yes, there are two outstanding orders, one for first quarter 2025, one for second quarter 2025.
would this, I mean, did they pay the fines on the first two?
They have not.
So I don't see why we would let them pay, order another 31,000. They're similar to Spin, and this is their third bite at the apple. Isn't this come to the point where they get banned?
So, and then the commission would have to find that this is intentional. I do have some information in the fall when I sent an email regarding the second quarter 2025. There was a response by a person who identified himself as Chris Lick, General Counsel of Scholastic. In that response, he apologized for Scholastic's delay and said that he would take care of this right away. I have heard nothing about, a few weeks ago, March 25th, 2026, I sent an email directly to him listing the two prior orders that they had not been paid. I directed him to the section of the law that talks about intentional violations. I directed him to the section of the law and listed the penalties to be outstanding and asked that this be addressed at his earliest convenience.
No response. Yeah, my question, I noticed that the service, there was no signature. It was, well, that email satisfies my concern that you've actually contacted somebody there. So,
I'd be in favor of levying fine.
Yeah.
And then referring it to the Attorney General's office to
Exactly.
actually collect on.
yeah.
This could be, what, 99,000 at this point?
Yeah.
I think we may have already referred the other two
The
to
other
the
two are
Attorney
with them
General's
right
office.
now, yeah.
Seemed to me that they are collectible.
Yeah.
Yeah.
So do we have a second on this motion?
We're just gonna see them back next meeting.
Right.
That's, I think, Rob's, or
Yeah, that's-
Commissioner Caruso's concern, excuse me.
Thank you, yes, it is, I mean, it's like, it's gonna
Bad
keep
penny.
building, and at some point, don't we have to draw a line with these guys?
And we also don't know, right, if they're not reporting and they are actually engaging in this conduct, it's even more problematic.
Right.
So if we were to issue, if we were to find it was intentional, and we were to issue a ban, what does that mean for their ability to actually still be out there and lobbying? And what's the consequence then? Because now we have people who are potentially out there doing work without any oversight.
Trying to look up the penalties for intentional.
So how do we proceed then with this case?
I think it's up to you to decide.
Well, I
So if
think,
there's a second on Paul's motion, then we would vote on that,
well, I think we have to find, I mean,
yeah.
and then,
Should we be doing this in public session or in a quasi judicial setting?
that's a good point.
It's all public information.
Yeah, it's all
Yeah.
public information.
Well, since we have a motion on the floor, I think we proceed and ask the staff to follow up and maybe take further action. Whatever that action may be.
I'm sure we have a second to the motion, Mr. Vice Chair.
There isn't, yeah, section, yeah. But let me ask this, if they don't pay after the 30 days and we have the third one that gets referred down to the AG's office for collection, at some point, could the investigative division bring this back to the commission with the recommendation that we ban them, or do we need to go through another quarter of them not filing?
I'm honestly not certain. I'm not certain whether we could bring this issue back as an investigative type case, the same. I don't know that I feel comfortable, to be honest with you. It does appear from the lobbying disclosure law that the commission has discretion to prohibit a person from lobbying. It's
Not aware during at least my tenure that we've done that in any of the lobbying cases.
I can't recall any of those.
I can, the penalties for for an intentional violation are found in 13A09E. And I can advise the commission of those if you would like. It says, for an intentional violation, a person who intentionally fails to register or report as required commits a misdemeanor of the second degree. A registrant who who files a report under this chapter with knowledge that it's false is a misdemeanor. That is set forward to a person that intentionally violates the chapter commits a misdemeanor in the third degree. In addition to the criminal penalties imposed under this chapter, the commission may prohibit a person from lobbying for economic consideration for up to 5 years for conduct which constitutes an offense under this subsection. Criminal prosecution or conviction is not required for the imposition of the prohibition authorized by this paragraph. The commission shall not impose the prohibition under this paragraph unless the person has been afforded the opportunity for a hearing, which shall be conducted by the commission in accordance with 1107-14 and 1108B. Those refer to the act, not the lobbying disclosure law. I would have to honestly look at our warning letter, and I'd have to look at our petition to see if we have, I'm assuming, as I don't know by heart, the notice of non-compliance gives them the option to request a hearing. So I would defer to the commission if that satisfies that requirement of them being afforded an opportunity for a hearing. One of our
This
notices.
seems to be a very unusual case. Rob, are you familiar with anything similar to this in the past?
None that I can recall in my time with the commission that we've had one entity do multiple failing to file. There's always some reason, or they will approach us with, our bad, or we try to work out solutions. In this case, it's,
They're completely avoiding us.
avoiding it, giving some
Right.
lip service of.
I think it's even worse. You have a member of the bar responding to a commission, an investigative division saying they'll take care of it and then not actually respond. I'm deeply troubled by this, but at the same time, I do think unless they are all of a sudden to file reports, we will see them again during the next meeting. And I would urge the investigative division to consider whether at that time it is intentional and provide the requisite notice that we will seek to ban them so that there's no argument about due process or notice at that time. Because what I also heard was that we have to have a hearing before we can ban them.
The opportunity.
We have to offer them the opportunity.
And I think that perhaps the safest thing is to move forward with the planned course of action today pursuant to the motion with that strong direction and comment on the record that this type of behavior is not sanctioned by the commission. And we have grave concerns about the fact that an entity could be out there lobbying without any oversight into what their expenditures are, which is the purpose of the lobbying act. So I would second the motion if others are comfortable that we've discussed it enough, but I don't want to cut off anybody's conversation.
I like that approach.
Well, that's fine. We can have a second and then have further discussion if anybody has anything more to say or any questions to add.
And your notice does say they can request a hearing and all that, so. Okay.
Okay, I'm good with that.
Any other comments or questions? Then on the motion, those supporting it, say aye. Aye. Any opposed? It's unanimous, and we'll send that forward with the information that we've provided here in this discussion.
Probably see them next quarter.
Yeah, I'm thinking.
Okay, administrative matters, we're on to an operational report.
Thank you. As I laid out in the memorandum that I submitted with the commission meeting materials, our fund, we're looking good for our budget for the remainder of 2025 and 2026. I actually have some adjustments to our grand total of surplus. We're currently calculating it to be in the $130,000 range to have a surplus for the 2025-2026 year or fiscal year. And the reason for that increase is staff vacancies because we did have a retirement and we do have another employee who has indicated she'll be leaving.
Mary, you keep cutting out. I don't know if anybody else can hear you, but you keep cutting out on me.
Okay, I'll try to speak up too.
Okay, thanks.
All right, we're projecting a surplus of about $130,000 for the 25-26 fiscal year. We have a balance of $122 from our 24-25 funds, and our continuing appropriation fund has a balance of about $176,000. We've conducted quite a bit of external training so far this year. We've actually conducted 21 in-person or virtual trainings. There was a few more since I prepared these materials. We've reached more than 850 public officials and public employees, and we currently have 11 more scheduled for 2026, although we get requests in every other day, it seems like, so I anticipate there'll be quite a bit more this year. We've also been approved by the Pennsylvania Continuing Legal Education Board as an accredited CLE provider. We provided our first training where we offered CLE credits last week, so people were very excited to get those credits. We had a little bit of trouble with processing the $1.50 and $3 checks. It's logistically a little tricky, but I want to commend our administrative staff and our legal staff for working through those issues. We've also conducted some internal trainings. I received feedback from staff that they were looking for more knowledge about things like the details of filing the Statement of Financial Interest, basics of the Ethics Act, nuances of the Ethics Act. We have that scheduled for later on in the spring. And then we're also going to do a training on the basics of state and local government. And we have people from staff internally here, training the rest of the staff on those items. It's something that we've been requested to do, and so I think it's a good opportunity to make sure that staff are fresh on all of this information. When I prepared this memo, the Commission's legal division had issued 19 advisory opinions in 2026. I expected, but there's a few more that have been issued since that time, so they're busy with issuing those advisory opinions. For investigations, as of the date of this memo, the investigative division has opened 12 preliminary inquiries, one of which was opened into a full investigation. We continue with our lobbying enforcement matters, as you know. We took some time late last year to meet with the Department of State's Bureau of Lobbying, of Campaign Finance and Lobbying Disclosure, and we've set up quarterly meetings with them to make sure that we are working together well in administering the requirements of the lobbying disclosure law. We actually just finalized a joint annual report on lobbying. It made sense to me that since both agencies are required and have duties under the lobbying disclosure law, that we issue a single annual report. And so we worked with their staff to pull our information that would ordinarily be in our annual report into this jointly issued annual report. So that will go out on time. We're working on a Q&A for lobbying disclosure to be posted to both of our websites. And we're looking for better ways to log and communicate between the two, to log calls and communicate between the two agencies. We provided an article for their lobbying newsletter. We plan to continue to do so in future editions. And we're just looking for any opportunities to improve our enforcement under the lobbying disclosure law. So far in 2026, we've issued a total of 13 warning notice letters to principals regarding their failure to file quarterly expense reports as required by the lobbying disclosure law. 4 of them did not file their quarterly expense reports or comply with the warning notice letters, and we will be seeking the assessment of monetary penalties and potentially other penalties, if appropriate, against the non-responding principals through the filing of notices of alleged noncompliance with the Commission. We have recently referred additional cases to the Attorney General's Financial Enforcement Section. As I reported at a prior meeting, they had stopped accepting referrals because of an IT issue that they had. They have since began accepting them, and so we've referred all outstanding matters down to them for them to pursue compliance. When I drafted this memo, they had successfully collected $500 in civil penalties. That has gone up since. We're receiving information from them every few days that they've been able to successfully collect on more of these matters. So I look forward to seeing additional collections from them. We rolled out the new online Statement of Financial Interest filing system as a pilot in January 2026. Thank you to some of the commissioners that completed their statements of financial interest using that system and also provided really valuable feedback about it. We did find some issues with it that we have worked with the vendor to already correct, or we plan to correct on full rollout. We are targeting January 2027 for the statewide rollout of that system. So we're excited to offer that to our public officials and public employees across the state. On October 15th, 2025, Commission staff submitted its 26-27 appropriation request of $4.146 million to the Office of the Budget. Both the Governor's Budget Bill and House Bill 2400 would appropriate $4.118 million to the Commission, and the reduction in that amount was due to what was originally overestimated benefit costs. And so we corrected that. That was corrected in the lowered amount. The House Bill 2400 was passed in the House on April 14, 2026, and I'll keep an eye on where we stand with these appropriations bills and keep the Commission up to date on that. And then finally, we have a few staffing updates. As we have on the agenda, later on the agenda, our senior special investigator, Dean Bender, retired effective April 4th, 2026. And we plan to advertise to fill the open special investigator position shortly. And then we also received notice that John L. Whitney, she's our receptionist, clerk typist, accepted a promotion with the Department of Labor and Industry, and her last day with the Commission will be next Friday, and we are looking at various options to fill that position. Happy to answer any questions about our operations.
Any questions? Hearing none, how about we have a regulation update?
Everyone's favorite topic. Following the Commission's brief meeting on March 26th, 2026, the revised version that the Commission approved, which responded to the concerns that were raised by the Attorney General in the tolling memo, was sent back to the Attorney General's office for review. Remarkably, only 4 days later, the Attorney General's office approved it and sent it back to me with the signature of approval. And then on April 6th, I was able to effectuate delivery of our proposed regulations to the standing committees, which are the State Government Committee in the Senate and the Judiciary Committee in the House, as well as the Legislative Reference Bureau and the Independent Regulatory Review Commission. Later that day, ERC confirmed that our delivery was complete and contained all of the required information that they were looking for. The following day, I received notification from the Legislative Reference Bureau that our proposed regulations will be published in the May 2nd, 2026 edition of the Pennsylvania Bulletin. They operate on a very strict schedule. Julie knows that very well in terms of publication and when things have to be submitted by in order to be published. This, because of its nature, they have to put it into what I refer to as galley pages, and so it takes maybe a couple weeks for them to do that, and that is why the May 2nd date is there. After the publication on May 2nd, that begins the 30-day public comment period, and I'm hopeful that because we did a lot of work on the front end, that we may not receive a lot of comments on the back end in the public comment period, but if we do, all of the comments have to be forwarded not only to ERC, but also to the standing committees in the legislature. And at the close of the public comment period, that begins ERC's 30-day period to offer their comments and send it back to us. So once they send it back to us, we're responsible for going over all of the comments that have been made and responding to them in one way or another, whether we agree with the comment and we're going to change something, or why we are not going to change what someone has brought up in a comment. And we include that in the preamble with a response and comment section. And after that, we begin the delivery process all over again, with the final form regulation going to these standing committees and IRC, and then IRC will schedule a hearing for us, probably me, to answer any questions or concerns that they may have. So that's where we stand right now, based upon this, and depending on the number of comments that we receive and the nature of those comments, I would expect that we would be going to see IRC at some point in the summer, late summer would be my guess.
Any questions about that update?
It's just great you guys got this far. I'm really pleased that, a lot of hard work and congratulations.
Definite group effort.
Thank you very much. All right, I don't see Dan here, but I think we want to take a moment to recognize Dan Bender.
Yes, and we did invite him. We do have one other item, administrative item.
Oh, did I miss?
That's
Oh,
all
the
right.
budget letter.
Yes.
I'm sorry, I apologize.
That's all right. No, that's no problem. As in past years, we've prepared a draft letter in support of the commission's appropriation request for the 26-27 fiscal year, and I attached a copy of the draft letter. We would need to make an adjustment to it because I noted in this letter that in 2025, we continued our substantive review of our ethics regulations. I said we plan to begin the formal regulatory process in April, and I think we need to change it to we began, so it's really good. But I would like your approval of this letter. We would like to apply your signatures to it and send it out to the leadership and the appropriations committees, as well as the House and Senate leadership, the governor, and the Office of the Budget. And then I would also request assistance with some commissioners in attending meetings to sort of sell what our budget request is and explain why we're looking for the number that we are.
Good. Did anyone have, other than the change to update where we are in the regulation package, did anyone have any other comments to offer to Mary for the letter?
I thought the letter does a very good job on page 2 of discussing just how much work the commission has done to decrease the amount of time between opening of cases and the complaints themselves. That's something we've heard from people who have come before us and have, complaint might be a strong word for it, but have expressed concern. And I think in the meetings with the key stakeholders, we should really tout those efforts, because the investigative division has done a great job to getting things moving, and we've seen that in the data as well. Thank you.
All right, hearing no further comments, I think you have our permission to go ahead and have the letters distributed with our electronic signatures.
Thank you.
And now, you were about to say you had invited Dan Bender here today, but he wasn't able to make it.
Correct. We had reached out to him and let him know that we were going to recognize him today. He is busy. He is enjoying retirement. He's painting. He's a antique car enthusiast, and he's busy working on his cars. But he was very thankful that the commission was going to do this, and he assured us that he was going to watch the video once it's posted online.
Well, wonderful. Well, let me just take a moment on the retirement of one of our very long-time investigators who performed outstanding and honorable service to the commission. And we want to recognize now retired senior special investigator Dan Bender. A little background, Mr. Bender was initially hired with the commission as a special investigator in 1990. Over his more than 36 years with the commission, Mr. Bender served as every category of special investigator, 1, 2, 3, supervising, senior, and a training officer. He handled countless commission investigations with distinction. Some of his notable investigations include, speaking of being a car enthusiast and having that actually impact our understanding of a case. The Schern case, where many of you will remember, a township supervisor sold a used vehicle to the township, and the commission ultimately held that the effort to avoid losses in terms of the vehicle just sitting on the supervisor's car lot was a private pecuniary benefit, and that was through the good work of Dan Bender. There was also the Zangrilli case where a plumber foreman for the Pittsburgh School District engaged in self-dealing by selling plumbing supplies to the district. That person, in addition to having the ethics case, was criminally charged and served jail time. And the Wansak case, where a school district's transportation director awarded a contract to provide transport for students with special needs to his girlfriend. And all the money was funneled back to him to remodel a house. These and many cases help formulate commission precedent and interpret the law that we work with every day. Mr. Bender also helped train numerous investigators, including those that are working in the Eastern region today. In addition to his many accomplishments, Mr. Bender was also a strong supporter of the very worthwhile cause of the Pennsylvania State Employee Combined Appeal, known as SECA. That's the Commonwealth's annual workplace charitable giving campaign. And as an avid vintage car enthusiast, Mr. Bender participated in the SECA car show in 2024. And as a direct result of his efforts, the State Ethics Commission won the SECA award in 2024. As mentioned, Mr. Bender retired on April 4th, 2026, and on behalf of the entire State Ethics Commission and its staff, I would like to personally thank Mr. Bender for his many contributions to this commission, to the taxpayers of the Commonwealth of Pennsylvania, and thank you for his service. Is there anyone else that would like to make any comments?
Yeah, I worked with Dan for probably 30 of his 36 years with the commission. In fact, I interviewed Dan, and it was part of the hiring group that brought Dan on. Dan came on we hired him straight out of Penn State. He was very, very green, had no prior investigative division experience, but he came along. He developed to the point where he was willing to help on any cases, and there were multiple cases, particularly Wansak, that we had an investigator abruptly leave and left us with reams of bank records to go through. And I remember that case that Dan and I put it together, and Dan willingly took all of the bank records, and Dan was always known as the books and records guy for the commission. And Dan will be missed. He was a character. That's the best, I can say that. He always had different perspectives, but he always brought something different to the table that was always appreciated. But Dan will be missed.
Thank you. All right. With that, I do see, and I know we had a guest, even though this is not a meeting designated for public comment, but I know we had a guest and friend from Pittsburgh, Leanne Davis, who dialed in. Is there any additional public comment before we adjourn our public meeting today?
Well, I wonderful comments about this investigator, Dan. Can you hear me okay?
We can, yes.
Yeah, oh, okay, yes. Hello. Could you remind me the name of that third case? I've read that before, and I really enjoyed it because it's a good reminder that, when there's an unlawful pecuniary gain, it could be direct or indirect. And in that case, if I remember, it was a girlfriend, not a technical spouse, but it was a household member that received the financial benefit, and then it went, I think if I remember, to the child's tuition, something like that. So I don't know, I think it's commendable for whenever you have staff that are upholding the spirit of the law and, thinking about that conceptually. Because sometimes, when you look at different agencies, they can look at, oh, well, here's an exception. Maybe it wouldn't, Yeah, anyway, that's great, great work. I don't remember the name of that case though. I'm curious if you have it. It sounded like you said it a second ago.
Sure. Leanne, it's one second. I'm happy to send you a link to the.
Oh, yeah, thank you.
decision.
Yeah, thanks.
Sure.
Great. Any other comments from anyone? Hearing none, I'll entertain a motion to adjourn the public meeting.
So moved.
Second, I'm always adjourned.
Everybody's looking at me.
It's true, I turned left. All in favor of adjourning, say aye.
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 Uh,
We are adjourned.